the Georgetown Law Federal Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of the Constitution. Our resolution tonight is it time to abolish the exclusionary rule? We are thrilled to host the University of Florida Levin Law's Professor Tracy Maclin and Colorado Professor Bill Pizzi to discuss this critical question. There's really no one better for it. In addition, we are honored to have the esteemed judge, Richard Leon, who also teaches an outstanding congressional investigation seminar right here at Georgetown Law, and is about to hit his 30-year anniversary next year to moderate. We are deeply grateful to the Federal Society and to Georgetown Law for making the Daniel Webster Debate Society series a reality. I recognize our Chief of Staff, Megan Sherwin, to introduce you three stellar panelists. Please give our speakers a warm welcome.
The Honorable Richard J. Leon serves as a senior judge for the United States District Court for the District of Columbia. Judge Leon has held a number of significant positions, both in government and outside of it, too extensive to list exhaustively here, but among them are the following positions: senior trial attorney, criminal division, taxes, U.S. Department of Justice, deputy attorney, deputy assistant attorney general, Environmental and Natural Resources Division, U.S. Department of Justice, and Special Counsel, Whitewater Investigation, U.S. House of Representatives, Committee on Banking, Finance, and Urban Affairs. Judge Leon has also served as an adjunct professor, both here at the Georgetown University Law Center and at the George Washington University Law School. Judge Leon received his BA from the University of the Holy Cross, his JD from Suffolk University, and his LLM from Harvard Law School. Following his graduation from law school, Judge Leon clerked on both the Massachusetts Superior Court and the Rhode Island Supreme Court. Professor Tracy Maclin is professor of law and Raymond and Miriam Elric Eminent Scholar Chair at the University of Florida Levin College of Law. Prior to joining the University of Florida faculty, he was a professor of law and Joseph Lipset Faculty Research Scholar at Boston University School of Law. Professor Maclin has also taught at Cornell Law School, Harvard Law School, and the University of Kentucky College of Law. Before entering law teaching, Professor Maclin served as a law clerk for Judge Boyce F. Martin, Jr. of the United States Court of Appeals for the Sixth Circuit and worked at Cahill, Gordon, and Rindell. His scholarship focuses on the Fourth Amendment and the self-incrimination clause of the Fifth Amendment. He's the author of The Supreme Court and the Fourth Amendment Exclusionary. Professor Maclin received his BA from Tufts University and his JD from Columbia Law School. Professor William T. Pizzi is a member of the Emeritus Faculty at Colorado Law, where he's worked since 1975. He came to Colorado in 1975 after spending a few years as Assistant U.S. Attorney in New Jersey. He specializes in criminal law with special interest in foreign criminal trial systems. Professor Pizzi's belief in the comparative study of law has compelled him to coordinate many of the law school's study abroad programs. And he recently served as a professor on the Semester at Sea program. Professor Pizzi has been active in Colorado's legal community, working on the Colorado Bar Association's Ethics Committee, and most recently, serving as the reporter for the Governor's Columbine Review Commission. Professor Pizzi received his BA from the College of the Holy Cross, his MA from the University of Massachusetts, and his JD from Harvard Law School. Please give our speakers a warm round of applause.
Well, this is an interesting setup here. It's the first time I've ever been in a situation where my fellow panelists were over my shoulder. I couldn't see what they were saying. But we'll muddle through, that's for sure. I've been on the federal court in Washington, D.C. now my 23rd year. And I've had hundreds of criminal cases, hundreds. In fact, it might shock some of you to learn, not the professors, of course, that we have a 97% plea rate in the federal courts in the United States, 97%. In the 23 years I've been on the court, like I said, I've had hundreds of criminal cases. I've presided over probably roughly 70 trials, 6 or 7 of which were multi-month, multi-defendant trials. In those 23 years, I've granted motion to suppress evidence twice. Twice in 23 years. It's not what I would characterize as a common issue or problem. At least it hasn't been in my case, and I've had all kinds of big narcotics cases, fraud cases, a wide range of criminal offenses. I thought I'd start off by giving you that context to view this discussion in. And I'm assuming my colleagues throughout the country have a not too dissimilar track record in their own case. But I'll start off with tell you the story of the first case. This ran a motion to suppress evidence with the exclusionary rule. 2 young men, African Americans, were riding in a car. I believe it was a Ford Explorer, it might have been a Jeep. They claimed that the driver claimed that the window was half down. That was an open issue as to whether it was half down or half up. But the park police here in Washington, D.C. decided to pull the car over. And the reason for pulling the car over to see what was going on in the car, it was in the evening, it was late in the evening, about 11 o'clock at night. The reason for pulling the car over was because they said the tint on the window was too dark, which in DC is against the law. So police protection. If the driver's side is too dark, the glass is too dark, police can't see it if somebody's got a gun or something like that. So the driver claimed that his window was halfway down. They could see he was a young African American driver. So the police, of course, said that the window was all the way up. So they're just doing it because of the tint of the glass. Okay. So he pulls over the car, and he doesn't know how many people are in the car. At least that's what his testimony was during the suppression motion hearing. And he called in for reinforcement backup. So when the backup arrived, he got out of his cruiser and he went around the back of the car to the passenger window, knocked on the window, said, the window down. Show me license and registration, driver's license and registration. And he did. And he testified, the police officer, this is from the US Park Police, he said that when the window came down, there was an overwhelming odor of unburnt marijuana that came out the window. Unburnt. So he claimed, with his backup officer, who by then was at his side, he claimed that he moved around the back of the car and said to the driver, get out, I want to frisk you. So the driver got out of the car, he patted him down, and he felt something in the crotch area. And he reached in and pulled it out. It was 3 rocks of crack cocaine. And then he brought him over to the curb, put him in handcuffs, put him over the curb. Then he went back and looked underneath the driver's seat. It was a loaded Glock, 10 rounds, Glock pistol. And then, based on what he said, of course, he looked to see if there was any marijuana in it. And it turned out there was a cup of Burger King, as I recall it, might have been McDonald's. It was a cup, but the cup was half full with soda, and pushed down into the cup, into the soda, in a plastic bag was a half an ounce of milk. So now, of course, the cross-examination begins after the prosecuting was finished. And the defense counsel gets up, a former AUSA himself, Danny Honorado, one of the better criminal defense lawyers here in Washington. Danny Honorado gets up and says, when did you become an officer? I can't remember what the time was. How long have you been an officer? Is this the first time that you smelled when doing a encounter of this kind? Is this the first time that you ever smelled unburned marijuana? You sure it was unburned? He said, yes, it was unburned. said, is this the first time? He said, when you went to Flexi in Georgia for your training, Federal Law Enforcement Center, did you have an opportunity to smell unburnt marijuana? Yes, I did. And you knew what it smelled like, right? Yes, I did. Blah, blah, blah. So finally, Honorado says, can I approach? And so he and the prosecutor come up to the bench, and Honorado says, Your Honor, I have an expert witness outside that I'd like to call to the stand. So you have an expert witness. Prosecutor jumps in and says, can't call an expert without advance notice. I said, well, that's a trial. That's for a trial. There's no pre-notice for a motion hearing at this time. So that is going nowhere. I said, what are you calling this expert for? He said, well, he's an odorologist. Excuse me? He said he's an odorologist at the University of Pennsylvania. And he's going to testify under oath that not even a dog that works at the airport smelling bag, looking for drugs, could smell a half an ounce of marijuana that was unburnt in a plastic bag, stuffed down into a cup half full of soda. Couldn't possibly do it. So, well, that makes sense. So I looked at the prosecutor and I said, have you got an odorologist you want to call today? He said, no, I don't, Your Honor. I didn't know about this. I said, I see. We'll continue this hearing for a week. But my guess is you won't find an odorologist you can call to counter this story. And my guess is that if you give this breakdown of what's occurred here, your supervisors at the U.S. Attorney's Office, you'll decide to dismiss this case. Because obviously, if he's believed, the gun goes, the marijuana goes, and the rock cocaine goes. You got nothing left. And I'm ashamed to say, because I had a higher opinion. I'm an alum with the U.S. Attorney's Office, Southern District of New York. I know what would have happened there. But the U.S. Attorney's Office in D.C. at the time had a U.S. attorney whose judgment, let's say, was not as good. And they decided not to withdraw the case. They wanted me to grant the suppression motion, which I gratefully did. And you want to know something? To this day, 20-something years later, one of my few regrets as a judge was I didn't follow it up. I was so busy at the time. I didn't follow it up with a letter to the park police, person in charge of the park police, to make sure that this officer got reprimanded for perjuring himself. I assumed, which I shouldn't have, I was a relatively new judge on the court, maybe a couple of years. I assumed the officer was reprimanded by the police, by the U.S. Attorney's Office, and put on a list that they keep of officers who perjured themselves. DC, the U.S. Attorney's Office keeps a list of that nature. But it clearly was a case where the officer didn't tell the truth. He didn't smell the unburned marijuana. Now, he hit jackpot. He got lucky. He didn't know what the guy would have. He didn't know the guy would have three rocks of crack cocaine in his crotch, or that he'd have a Glock pistol that was loaded under the seat. But I granted that motion to suppress. It was probably 15 or 18 years later before I had a second one. So I don't want you students, I don't think the professors do either, so I'll speak for them at the same time, to get the misimpression that this is a common problem that we have every day in the federal judiciary. But it is a potential problem. And I'm glad that we have experienced professors who are willing and able to take on the issue and debate it back and forth. So I'm looking forward to hearing from them too. Why don't we go to, I think we go to Professor Pizzi first, right? I don't see him.
Can you hear me okay?
I can see you now, my fellow crusader.
Is it okay? Can you?
I can hear you. Can you hear me?
Yes, I can hear you just fine. Okay, I want to emphasize a couple things. First of all, I'm really old. I haven't been back to the Fourth Amendment in 10 or 11 years, so I hope what I say is not antiquated. But secondly, I'm a comparatist. I've sat in courtrooms in many countries, many Western countries, many Asian countries, wherever I go, I always go into, if I'm on a vacation, I always go into the courtroom to see what they do and learn from them. And you'll see that in what I have to say. I'm not I'm not opposed to exclusionary rules. I am opposed to the way this rule is structured. I start by saying deterrence is a cancer. You want to keep it out of your system as best you can. And when it's in there, you want to try and stamp it out. We are the deterrent capital of the world. We have harsh drug penalties, we have harsh gun laws. We think it's effective and it's going to work. And I think it's a big mistake. You won't find those laws in other Western countries. They take the principle of proportional punishment very, very seriously. I'm going to talk a little bit about, just mention Canada. It's a common law country. It has our same heritage. It's a fundamental principle of criminal law in Canada. Punishment should be proportional to the gravity of the offense and the degree of the responsibility of the offender. I think that applies to offenders who violate the law. I think it also should apply to police officers who violate the law. If it's intentional, that's one thing. If it's in good faith, that's something else. Okay. Now, we have a macho exclusionary rule. If the officer in good faith makes a mistake and an appellate or court later says there was no probable cause, sorry, officer, we're going to suppress that in theory, all that evidence. It puts tremendous pressure on the concepts of probable cause and reasonable suspicion. These are concepts that cannot bear that kind of pressure. I taught criminal procedure for many years. I loved classroom discussions, students arguing about, was there a probable cause in this case or that case? And then I give them another fact. How about now? Well, yeah. Is probable cause like 2 out of 10 or 4 out of 10 or 6 out of 10? It's not, the court has given us very little guidance because there can be very little guidance on these sorts of questions. I think, should probable cause, should we allow weaker probable cause in a murder case and much harsher probable cause in a drug case? We can argue these things, but I mean, I think what the police are trying to do on the street, especially in serious cases, under a lot of pressure, it's not easy what they're trying to do. They should be punished, certainly, for intentional violations or for testifying. Okay. But many search and seizure issues are judgment calls. You would call it one way, I would call it another way. You see that in appellate opinions all the time, where judges disagree. The Supreme Court, in a case I used to love, Gates versus Illinois, it's a warrant case, and there's all these crazy facts, and the court is split over whether there was probable cause or not. And I want to say, as I often felt in my Castron discussions, you're both right. You're both right. You would call it tougher. You would call it maybe less tough. Many of the decisions that come down in the search and seizure area are fact-bound decisions. They don't really help us in the next case. There will never be one exactly like that. Okay, now, I'm not against exclusionary rules. Other common law countries have exclusionary rules that balance a number of factors. How serious was the violation? What was the pressure on the officer at the time? Was the officer negligent or reckless? Did the officer act in good faith? How serious is the crime? What is the importance of the evidence? And they weigh these kinds of factors against whether the admission of the evidence would undermine respect for the system's integrity. I'm not saying it's easy, but it's honest. Now let me get to by the way, none of them base their exclusionary rule on deterrence. They specifically do not. They want deterrence out of their systems. A macho exclusionary rule encourages police dishonesty and judicial dishonesty. When you have a rule that punishes a police officer in good faith, officers close ranks. They say, you don't understand us. You don't understand what it's like out there. And that's not healthy for your system. The others, it's not a good system. Judicial dishonesty it's a well-known phenomenon. I will say this as a former federal prosecutor. I knew when it was a serious case, there's no way that evidence is going to be suppressed. I've heard people who do drug cases talk about, I think it's the 1 kilo rule or something like that. If it was below a certain amount, you got a good chance at suppression. If it's above that, you're not going to get it suppressed. So I don't think that dishonesty is good. Criminal cases are not two-sided. When in the 1960s, it was a very different period. There was no National Association of Victims Assistance. The victimism movement really didn't take off until the 1980s. It's an international movement, and they get caught in the crossfire in a serious case, in a murder case, in a rape case, in an assault case, and they get ignored. And now, Mapp would not be decided the same way today. The briefs would be very different, and I can assure you of that. Okay, I think I will stop there and let Professor Maclin.
Okay, I'm waiting for the judge to signal me to speak.
Just so happens it's right on schedule. 22 hours. Go right ahead, Professor.
Thank you, Judge, and let me just thank Brady for inviting me, and Judge Leon. Thank you, and Professor Pizzi. Excuse me. I want to thank you. I'm sorry I wasn't able to be there, although I am not sorry that I am in 75 and sunny weather down here in Florida. I understand it's a little cooler in the District of Columbia. I want to make 3 points here, and I'm going to try and stay within my 7 minutes, but I want to make 3 points that connect up the exclusionary rule, and then Professor Pizzi and I will respond to the judge's questions. First is every lawyer and every judge admire Justice Oliver Wendell Holmes. All right. Even Justice Scalia called Holmes one of the nation's, quote, greatest justices. Interestingly, opponents of the exclusionary rule rarely acknowledge and almost never praise, or not almost, never praise Holmes's view of the Fourth Amendment and the exclusionary rule. Put it simply, Holmes viewed exclusion not as resting on a deterrence theory or upon a merger of the Fourth and Fifth Amendment, which was one of the arguments at the time when Holmes was alive and writing opinions on the court. Rather, the constitutional bar on the use of illegally seized evidence in Holmes's interpretation of the Fourth Amendment derived from the Fourth Amendment itself. Don't take my word on it. Read Silverthorne Lumber versus United States. My second point is the following. Weeks versus United States, which was decided in 1914, grounded exclusion on the Fourth Amendment itself. To the students out there, read Weeks carefully. You will see, among other things, Justice Day saying if the government can illegally obtain and use and admit evidence at a trial, the Fourth Amendment has, quote, no value to a person like Fremont Weeks. And also pay attention to what Weeks did not say, okay? Weeks doesn't describe exclusion as a remedy. No mention is made in Weeks of the effectiveness of exclusion versus tort remedies, police discipline, or other remedies. And most important, and I think Professor will like this, most importantly, there is no discussion in Weeks of deterrence or of the court's supervisory authority. My point is simple. Weeks based exclusion on the Fourth Amendment itself. Weeks was a remarkable decision because the precedent prior to Weeks, as some of the students probably know, and certainly the professor knows and the judge knows, was a case called Boyd versus United States. Now, Boyd based exclusion on a merger of the Fourth Amendment and the Fifth Amendment, which was frankly not a very persuasive or logical argument. When Weeks was argued, both sides talked about the Fourth and Fifth Amendment merger theory. Interestingly, Justice Day's unanimous opinion in Weeks does not mention the Fifth Amendment. It is solely focused on the Fourth Amendment. My third point is, I guess, more practical and a little bit of constitutional history. Shortly after Mapp versus Ohio was decided in 1961, a New York Times reporter, Sidney Zion, secretly recorded the remarks of the head of the NYPD's legal division. He had given a talk at a conference for detectives of the NYPD. And the official said, and I'm going to quote it from a book that you should all go out and buy by Tracy Maclin. It's on page 83 of the book. And I told Brady this when he first contacted me back in the summer. I said, you know, Brady, more people should read this book, but I understand why they don't, because it was originally priced at $89. And it's just crazy, right? And I didn't get any of the money. So that's neither here nor there. But anyway, at the conference, this head of the NYPD said to the gathered detectives, and I quote, "The Mapp case was a shock to us. We had to reorganize our thinking, frankly. Before this, nobody bothered to take out search warrants. Although the US Constitution requires warrants in most cases, the US Supreme Court had ruled that evidence obtained without a warrant, illegally, if you will, was admissible in state courts." And that, of course, is a reference to Wolf versus Colorado. So the feeling was, why bother? End of quote. In other words, what the NY head, not some flunky, but the head of the NYPD was saying, look, we knew we were supposed to go get warrants when we go out and search people's homes and other areas of privacy expectation, other areas that enjoy expectation of privacy. But why bother? The evidence was coming in anyway. My professor, who I'm sure the professor knows, H. Richard Uvula, used to tell the story right after Mapp was decided, because he took extensive notes on Supreme Court precedents. In fact, he argued many Supreme Court cases when he was the head of the Manhattan DA's appellate division under DA District Attorney Hogan. He was at a conference and Mapp was decided, and he started reeling off all these cases that he had kept track of. And as he told us later, he had a bestseller. And this was at a conference of prosecutors, not police officers, prosecutors. Why did he have a bestseller? Because nobody paid attention for the most part to the law. Because again, the feeling was, well, we know Wolf says the Fourth Amendment applies to the states, but it really didn't. But they also said in the next breath that there's no exclusion imposed on the states. So states like New York and California and Pennsylvania and Ohio, they didn't have to worry about illegally evidence not coming in because it was going to come in. I guess my point is, without exclusion, we didn't have effective enforcement of the Fourth Amendment. That's why Mapp was such a shock to the head of the NYPD legal division and to prosecutors all over the country. Okay. And I guess the point I want to leave you with, and I think I've kept it within my 7 minutes. Opponents of the exclusionary rule like to say that the rule handcuffs or restricts the police. That's dead wrong. The exclusionary rule does not restrict the powers of the police 1 inch. The Fourth Amendment does. The problem for many, however, is that the exclusionary rule simply reminds us of the price we pay for having the Fourth Amendment. Okay. And then one little final point. The judge is right and the professor is right when they talk about how it's really not that much of a problem. Because if the police act in good faith, there's going to be no exclusion. And again, don't take my word for it. Let's listen to the Chief Justice of the United States, Chief Justice Roberts, in Herring versus United States, where the Chief Justice said, and I quote, "To trigger the exclusionary rule, police conduct must be sufficiently deliberate that exclusion can meaningfully deter it, and sufficiently culpable that such deterrence is worth the price paid by the justice system." And of course, the good students in the audience who are paying attention in their criminal procedure class know that Herring was reaffirmed in Justice Alito's opinion in Alito. And if there was any argument that Herring was a narrow case, Alito made plain in Davis that no, what we said, what I just quoted, is indeed. So what you have now is essentially the exclusionary rule is limited to cases of deliberate, culpable police misconduct of the type we saw in Mapp versus Ohio. So if the police officer is acting in good faith, there's going to be no exclusion. Now, that doesn't mean that we should dump the exclusionary rule. It does mean, I guess I want the students to understand, that when you hear about all this handcuffing of the police, it's not true. The exclusionary rule has its greatest impact, as the judge suggested, in narcotics cases and gun cases. You rarely see the exclusionary rule being applied in murder and rape cases. That's in part because there's other evidence outside of what the police sees, but it's also in part because of what the professor said about how in those grisly cases, judges are reluctant to exclude. I think I went 2 minutes over my 7 minutes, so I apologize. I'll stop there.
Well, actually, you each get 2 minutes to rebut the other, so we'll start with Professor Pizzi. And he has
Well,
2 minutes. 2 minutes.
I agree with a lot that Professor Maclin said. I agree completely that it's not a problem in serious cases, and it applies mostly in drug cases. I agree with that. I just think the system is not honest about it. And, to say, oh, this won't deter, this will deter, there's a lot of empirical evidence on deterrence. We've been arguing about deterrence for years in the death penalty and all kinds of things. And why not just go back to judicial integrity? We shouldn't be sanctioning behavior that is shocking. That's all really all I'm saying. I don't think the outcome will be any. There are certainly strands of that in Mapp. But then the court went the wrong way by just saying, it's not really judicial integrity. It's deterrence. And I think that's unfortunate. The court has boxed itself into a very difficult situation on when we get to sentencing. What can they do about these very difficult deterrent sentences that hit too many of our citizens? when they have endorsed deterrence. So I guess I'm really arguing. I'm really not arguing, I guess, to abolish the exclusionary rule. I'm just saying change the foundation here and recognize that that's what it's really about. And recognize that you are always implicitly balancing these issues in serious cases, even if you don't say it. Other countries, they explicitly balance it. They can say things that should be said. Officer, what you did was sloppy and wrong, and you deserve to be punished for that. But you did find a tactical nuclear weapon in that garage or something like that. You know, let's be honest. And so that's really what I'm saying. And back off deterrence and join the club of common law countries that have a much more proportional, an exclusionary rule based on judicial integrity and how the system should handle police misbehavior.
Can I respond to that, Judge?
Yes, you get a 2-minute rebuttal or 2.5.
Well, I don't disagree. I mean, I know Brady was hoping for a fight. I don't disagree with what the professor is saying, but I want to make 2 points, because he said in his opening remarks, he says, well, we need to punish the cops. That's not going to happen in America. That's not going to happen. Now, the judges don't have a worry about responding to the police unions, but the police unions are never going to put up with a system where we are actually punishing police officers for violating the Fourth Amendment. All right, Chief Justice Berger suggested that back in the early 70s, and it went nowhere. The other problem I see with punishing individual police officers is I think you're going to get more testifying out of that, because if police know, I mean, again, no judge is going to send a police officer to jail for violating some drug dealer's Fourth Amendment rights, especially when they found drugs or they found the gun. That's just not going to happen in America. But even if you threaten a police officer with monetary fines, all right, the cops are just going to start to lie more about what's going on, because they're going to say, look, it's not going to come out of my pocket. So my fear is that if we move completely away from the deterrence theory, all right, it's just going to encourage some of the bad stuff that Judge Leon talked about in his opening remarks. And then let me just finally say, and I'll shut up, this Supreme Court, the current Supreme Court, is about abolishing the exclusionary rule. If the students read Hudson versus Michigan carefully, Scalia had, or at least he thought he had, the 5 votes to abolish the exclusionary rule. Hudson versus Michigan, of course, is the case in which the court 10 years earlier had said, oh, the knock and announce requirement, that's part of the Fourth Amendment. So when police go to execute a warrant in a home, they need to knock and announce first. 10 years later, they say, well, if they don't knock and announce as the Fourth Amendment requires, we're never going to exclude. Scalia's opinion is a roadmap for abolishing the exclusionary rule. What happened was, in my estimation, Kennedy got cold feet and he went along with the opinion, but he wouldn't join an opinion that said we're going to abolish the exclusionary rule. Then came Herring and Davis, and I submit that Herring and Davis basically say we're never going to support exclusion, we the court, unless you have an egregious situation. And as the judge will tell you, most suppression hearings, both in federal, especially in federal court, but in state court as well, don't involve the type of facts we see in Mapp versus Ohio. As the professor said, most suppression hearings are about judgment calls. The cop thought he had probable cause to search the car. He thought he had reasonable suspicion. A judge says, well, you were close, but not quite there. And so he rules against them, and the evidence is lost, right? Those are not the types of cases that the Supreme Court thinks there should be exclusion. If there's good faith, we ought to let it in. Now, they haven't said that in the case not involving record keeping, but they will say it. I submit to the students, you wait. There's going to be a probable cause car search case. There's going to be a Terry stop case in which the police are going to be close. Someone like Judge Leon says, well, you know, you didn't quite have reasonable suspicion. I'm going to rule for the government. And then the prosecutor is going to stand up and say, well, Judge, can I get you to say that the officer was operating in good faith? Judge says, yeah, you want that finding? Here it is. They're going to take that up to the Supreme Court, and the court's going to say no exclusion because there was good faith. And they're going to say that in the run-of-the-mill Fourth Amendment case. And once they say that, exclusion is done.
All right, let's open it up to questions from the audience. Who'd like to go first? All right.
I guess for Professor Pizzi, I was wondering, what would your alternative be to the Fourth Amendment exclusionary rule? Is it more so criminal or tort liability for cops, or what kind of alternative do you think is most desirable in our system?
I mean, I think you have to rely on the police to discipline themselves, and you've got to be honest here about when a police does something shocking, does something wrong. When in Judge Leon's case, a police officer lies, they deserve to be punished, but not by the exclusion of the evidence, especially in a very serious case. But just to credit in serious cases, police test the lying, and so you don't have to suppress the evidence. That's not right. Now, I mean, I just think that the are the police in Orlando any more likely, any better, more respective of the rights of citizens and the peace than the police in Ottawa? I don't think so. And they don't have a deterrent exclusionary rule. And so, I mean, I can think of many alternatives to the exclusionary rule. And, Sweden has no exclusionary rule, but they have a very powerful ombudsman system that can go into any police department. They don't even have to get a complaint. They can just go in there. If they read in the paper or hear that something went wrong, they have tremendous power, and and it works very, very well. Okay, how do you discipline the police? I don't think this system is fair. I agree that okay, maybe we're getting close to good faith. Okay, and that you still violated the rule, officer. You didn't have probable cause, according to your rule. So, I mean, I just think a more honest system and back off the deterrence. That's really, I don't know. Okay, I'll leave it at that.
Maclin, would you like to respond to that question?
No, I'm good.
Okay. I think we had another question. Yes, sir.
Yes, I also had a question for Professor Pizzi. You've talked about some of the drawbacks of basing the exclusionary rule on a deterrence justification. I was wondering how receptive you would be to one of the other justifications for the exclusionary rule that the court laid out in Mapp, specifically that when the court allows evidence that was obtained in violation of the Fourth Amendment into a case, they're making themselves complicit in the violation of someone's Fourth Amendment rights, regardless of whether the police obtain that evidence in good faith or not. Don't you think that's an independent justification for having an exclusionary rule, and one that's just as, if not more, compelling?
Well, I think it's a balance, and are you going to suppress in a murder case when the victim's family's there, or a very serious case where the officer in good faith, which should have waited for a warrant, should have gone for a warrant? Are you going to suppress? I mean, I think that's a very difficult balance, and so I think I like the theory. You have to ask about, does this undermine respect for our judicial system? So I mean, I like the judicial integrity basis that was in Mapp, and I thought if only the court would fasten on that, it would have been better. But so, I don't, you know, I think the balance is wrong. If the officer in good faith comes up short on probable cause and you're going to suppress a murder weapon, I don't think that undermines respect for the system's judicial integrity in that situation. It's not fair. It's not proportional. And I think, every other countries would come to the same conclusion. But I think you have the right point. I mean, that's the balance of factors we have to take into account.
I think someone had a question over here. No question.
Yeah, thank you both, and thank you, Judge. This has been a lot of fun. I think just as a matter of individual rights, why does the good, and this may be more to Professor Maclin, why does the good faith standard matter at all? It's like if a public university suppressed someone's free speech in good faith, that would not change the sort of court's analysis in a meaningful way. Why should it for exclusionary rule analysis?
Are you asking me as my opinion, or are you asking me about the Supreme Court? I agree with you that good faith shouldn't be on the table, and I agree with Professor Pizzi on this. If you violate a person's Fourth Amendment rights, then the evidence ought to go. That was Justice Holmes's view. That was the view endorsed in Weeks. I don't think good faith should matter. If you're asking me directly if I were ruling the world, that would be my Fourth Amendment system. And then you violate a guy's Fourth Amendment rights, then it gets out. And one problem I see with the balancing, I mean, it's kind of similar. And again, the students who are taking criminal procedure will understand what I'm talking about here. It's kind of similar to the situation we had pre-Miranda with respect to whether a confession is going to be admissible under the old voluntariness test. Okay, under that test, everything mattered. Everything was relevant, but nothing was controlling. All right. And Miranda came in and said, look, we got to give some guidance. Got to give some guidance to the police officers and especially the detectives. And we got to give some guidance to the judges like Judge Leon, all right, as to whether or not a confession is admissible under the Fifth Amendment. If we go with a totality of the circumstances, everything matters, the egregiousness of the crime, what was the officer thinking at the time, had he been involved in similar misconduct, then again, you get this mishmash of thinking, if you violate the Fourth Amendment's right, if you violate the Fourth Amendment, evidence goes, case closed.
And then just, Professor, the brief follow-up on that, Professor Pizzi, sorry.
I just have one follow-up to that. Miranda is a very clear rule that can be obeyed. Give the warnings, or make it clear that the subject is not under arrest. I mean, that's a very clear, that's a very different situation than going out at night and let me say something about my state here. We have many of our search and seizure issues and criminal procedures come from rural counties. We have very rural counties here where the police, these are not FBI agents with law degrees. These are young people out there. They don't usually they do traffic mostly. Suddenly there's a shooting. They're frankly in over the head. They're going to make some mistakes. And so I come from that understanding that we have to, they don't have necessarily the same experience as a big city officer. So I think, and they're in, gosh, what am I supposed to do here? How do I do this? And so I think it's a very different, do I need a warrant? I don't know. I can't get a warrant. I'm in a mountain town. Okay. Anyway, so Miranda, I agree. I mean, it's a nice, clear situation where the police can easily control that. Give the warnings or make clear the person isn't under arrest. But the Fourth Amendment is just, it's just it, these concepts of probable cause, reasonable suspicion are not clear. They're judgment calls.
Well, listen, I want to push back a bit.
Okay, sure.
Professor Pizzi is absolutely right. They're not clear because the Supreme Court has refused to make them clear, right? It was Chief Justice Rehnquist, right? In Ornalis, he said, look, we're not going to define probable cause. We're not going to even define reasonable suspicion. Now, so the professor's right about that, but it's not that hard. You only need a warrant if you're going to go into a person's home, you're going to wiretap somebody, or you're going to do forced surgery on an individual. Everything else is pretty much probable. You want to do a car search? You got to have probable cause. You want to arrest a person? You got to have probable cause. All right? You want to do a Terry frisk? You got to have even less than that. So when they say, oh, the Fourth Amendment is so complicated, it's so hard on the police officers, it's not that hard. They have to have warrants to go into homes and the wiretaps. And the officer in the field is not making a decision on the wiretaps, right? The officer in the field is not making the decision that we saw in Winston versus Lee about forced surgery. Outside of those special areas, they don't need warrants. All they need is probable cause. I am very sympathetic with the argument that probable cause is not defined, but that's not because of the exclusionary rule. That's because the Supreme Court, as the professor pointed out, in Illinois versus Gates, went out of their way to not give us a standard. They said, well, probable cause is a fair probability. Well, what the hell is that? It's a substantial chance of criminality, right? But it's not a preponderance. It's not even a more likely than not standard, which means it's not 50% or over. Well, if probable cause is not 50% or over, what the hell is reasonable suspicion? Is that 10%, 20%? But my main point here is Fourth Amendment is not that complicated to follow.
Well, that's a question.
I had a follow-up, if that's all right. Thank you, professors. Just kind of on to Professor Maclin, like if good faith doesn't matter, I guess sort of
It shouldn't matter.
Yeah. If is it a problem for the court system, kind of judicial integrity, to tell a victim that, hey, we got the real criminal, but we cannot bring him or her to justice because the officer messed up along the way? Like that seems like a difficult justice question.
Well, I mean, are we talking about justice questions or are we talking about the Constitution? I mean, the Fourth Amendment was put in there knowing full well that fewer people were going to be caught. I mean, we have the Fourth Amendment because the colonists and later the folks during the framing era, many of them were the 17th century, I guess not 17th, 18th century equivalent of drug dealers. They were bringing in wine and molasses and sugar from the Caribbean, and they weren't paying taxes on it. The Brits were pissed off that they weren't paying taxes, and they sent in the customs officers into people's homes and warehouses to look for these untaxed goods. And they used what were then known as writs of assistance. And I assume some of you in Professor Butler's class and other classes have talked about the history of the Fourth Amendment. They used writs of assistance and general warrants to go into people's homes and to look for these untaxed goods. This was contraband, right? And when the Fourth Amendment was put in the Constitution, it was put in there knowing that fewer people, fewer criminals were going to be caught. So you say, well, what are you going to tell the victim's family? You tell the victim's family, you know what, we're going to do better, and we're going to train our police officers better in the future so they don't make these mistakes, so these criminals don't go free. But again, the exclusionary rule has almost no impact in murder cases and in assault cases. Its greatest impact, and it's less than 10%, is in drug cases and gun cases. And why is that? Because if you throw out the evidence seized by the cops, you got no case left. And I think the judge will back me up on that. That's where the real impact of the exclusionary rule. It's not in murder cases. It's not in rape cases. It's in drug and gun cases because possession matters in those cases.
I'm still trying to figure out where the cry is to get rid of it. Where's this groundswell of opposition to the exclusionary rule?
It's in the Supreme Court, Judge. The students ought to read Clarence Thomas's opinion in Collins versus Virginia, which was the most recent statement coming out of the court, although Thomas was speaking for himself. Read Thomas's concurrence in Collins versus Virginia. And everything that he says in that concurring opinion, he's going after applying the exclusionary rule to state cases. But every one of his criticisms applies to federal cases as well.
Well, I'll ask him.
Roberts?
I'll ask when I went to them on Tuesday. What the big concern is about that? Because I haven't heard any clamor. You know, we were classmates in college. We haven't had any clamoring, as far as I can tell, in the federal judiciary with regard.
Well, maybe not the federal judiciary, but the Supreme Court. I guarantee you, if given the opportunity, Roberts.
The federal judiciary.
The Supreme Court's not the federal judiciary?
That's a part of the federal judiciary.
Oh, I didn't say they. Okay, fair enough. Yeah, but what they say matters. Well, you say one justice. Roberts, Alito, Thomas. I don't know where Gorsuch and Kavanaugh stand because they haven't spoken to it. I don't know where Comey stands, but I guarantee you that those first three, Roberts, Alito, and Thomas, would get rid of the exclusionary rule in a heartbeat. They just need the right case, and they need two more of the three.
I'm not as
and
confident.
then it's done. I'm sorry?
I'm not as confident as you are, Professor.
Okay, well, just read the cases.
I'll ask him myself.
You'll ask Thomas? You'll ask Thomas whether he wants to get rid of the exclusionary rule? And will you share his answer with the public, or at least with your class?
No.
Oh, okay.
Confidential conversation.
Of course, yeah.
I can tell you on the record, I have not heard of any clamoring within the federal judiciary, excluding Justice Thomas, in your mind, that this is a big problem that we have to deal with. Like I said, when we started.
That's because, Judge, if you're right, that's because under the precedents, I'll quote Steve Duke at Yale Law School, the exclusionary rule after the Berger and Rehnquist courts have decided so many cases, it's basically chicken broth. It's chicken broth. There's no.
Chicken broth.
What's that?
I'm not sure how you define chicken broth.
It's not very effective.
I'm telling you, from 20 plus years on the court, this has not been a real problem or an issue.
Well,
Telling you from experience.
I'll defer to you. I'll defer to you, Judge.
Now, there might be a big problem, this bigger problem in state courts. I'm not saying it is or it isn't because I haven't studied that. But I don't think it's a big problem in the federal courts. And I haven't heard of any clamoring during the political season we just went through last year or anything about that being a primary issue. God knows President Trump, if it was a primary issue, he'd be all over. He's over every damn issue in the world. We just went through a whole January 6th situation in our court. Yeah, so.
Well, I'll say one last thing. One reason why there may, and this is speculation on my part, I'll concede, is that the rule, the precedents are such that it's rarely going to be a lawful basis for exclusion under the precedents, including Herring and Davis and all the other cases. So, but you're closer to the scene than I am.
I'm curious where you and Professor Pizzi get the notion that judges bend over backwards in cases that have serious cases in doing their analysis of the probable cause. They bend over backwards and against allowing the exclusionary rule to get rid of the evidence in those cases, right? I don't know, how do you know?
You're asking about judicial dishonesty?
Yeah,
Is that-
what's your basis for that? In the federal judiciary in the United States, what's your basis?
I saw it as I did a lot of appellate work. I did,
When you were in the U.S. Attorney's Office in New Jersey,
yeah, that was it.
Justice Alito was an
And
appellate
I've
lawyer.
talked to a lot of people, and it's just I've read a lot about the drug cases, and we do. I mean, I am certainly not going to tell you that murderers get off or terrorists get off or rapists get off because of the exclusionary rule. I agree completely with Professor Maclin, but every so often there's a case, and it in state court, and it raises real issues. It's a very close, difficult case, and a judge, and there's an uproar. It sometimes happened in federal courts. You remember the Carol Bayless case in New York City that where some federal judge said they didn't have probable cause to go in there or whatever. That wasn't a drug drop, and we're talking about I don't know, giant amounts of drugs, and everybody spoke on that, up to even President Clinton spoke about it. So these don't
Bill, talk to him. Talk to him about Brewer versus Williams. Talk to him about Brewer versus Williams.
And there's the Supreme Court,
Talk-
the convention there, and there's the Supreme Court saying, "Hey, try inevitable discovery."
Well, it's worse than that. I mean,
the Supreme Court is saying, I'll tell you how to get that in. Try inevitable discovery. Sure, you would have found it. So there are a lot of exceptions that judges can use, and that's a big one.
But Bill, give him the history of Brewer versus Williams. All right, Brewer versus Williams is not a Fourth Amendment case.
2 minutes. You get 2 minutes.
Yeah, it's a Sixth
2 minutes.
It's a Sixth Amendment. Let me step in. Judge, you say, well, what's the knowledge? Look at the dissenting opinions in Brewer versus Williams. They don't talk about the merits of the Sixth Amendment. Berger and Blackmun, Blackmun was the darling of the liberals when he retired from the Supreme Court. Blackmun was terrible on the Fourth Amendment and the exclusionary rule. But read Berger. Tell the students, read Berger and Blackmun's dissents in Brewer versus Williams. They don't talk about the merits of that case. All they talk about is how this is a terrible crime and you're letting loose this child killer. And Professor Pizzi is right. Then they go out of their way in the dissent and in the majority say, look, this is what you need to do on retrial. There's a new exception. It's called the inevitable discovery exception. There's proof that the Supreme Court itself bent over backwards to change the law because of the heinous nature of a crime. Am I right about that? Am I wrong about that, Bill?
No, I agree with you completely. Whether they ever would have found the body, it was in even another county, but again, I'm sure they could. I don't know what happened at the hearing, but I'm sure the police said, "Oh, we would definitely have been going into that other county." But would an animal drag the body away? I don't know. Terrible case, and
not only a terrible case, a case of deliberate police misconduct. That detective knew he shouldn't have been talking to Williams. He knew it, but he did it anyway. And it wasn't as if the law wasn't clear. It's called Messiah. Any student in my criminal procedure class who would have okayed that detective's behavior would have gotten an F. And I assume the same is true for the students taking Professor Butler's class. So there was an instance where the Supreme Court justices themselves responded to the heinous nature of crime facts, and were willing to change the course of the law, constitutional law.
Well, it sounds to me like the two of you are more in agreement with one another than disagreement. I'm not so sure that the resolutions Uh,
I doubt we would agree on Miranda and on another, and on other issues, or on, well, okay.
Would either professor wish to make a closing statement? It's not necessary, but it's up to you.
No, I think I've said enough.
It's a beautiful
Well, I
day in
guess
Florida. You can go out and enjoy it.
I'd say just to the students that, I've been in a lot of different trial systems, and I don't care where you are. If you say, how is your system working? They always say, we have big problems, and, no one has a perfect system. I think I think our criminal law is way too harsh. And, when as you heard, and I think it's a problem. And I think we have all these trial protections, pre-trial trial protections, and you get the sentencing, and we have very few protections, and people get brutal sentences. And I think that's a major problem. It's a big problem in the federal system.
Well, we have 97% pleas in the federal system.
Well,
97.
you get these very brutal sentences. When these people don't plea bargain, they get really brutal sentences, and I could go into that, but that's not really about so I think I don't want to abolish the exclusionary rule and say we don't care what the police do. I just go back to, I care very much how it's structured and how we talk about it and how we criticize police behavior. I would like a more honest system. Thank you.
I guess I would say to the students, and this has nothing to do with the exclusionary rule, but when you graduate, and for those of you who are actually going to be prosecutors and public defenders, and even those who aren't, be prepared. Be prepared. Read the cases. Too many lawyers don't read the cases carefully, and the ones that do, when they get in front of judges like Judge Leone, all right, when they know the cases and they can back up their arguments, they're more likely to succeed, because when judges are fair and judges are open-minded, they listen to the people who are prepared and know the law. And so I just would urge the students, always be prepared, and the habits you develop in law school will be the habits that you take once you start practicing. And thank you for inviting me.
Well, let's give them a good round of applause. Spirited debate. Thank you for putting it on.
Thank you.
Have a great evening.